Everyone, how are you? I hope you got a little bit more energy than I do right now. My name is Dana Moore. I'm the director of the Office of Equity and Civil Rights. I want to welcome you to round 2 of the first day of the Civil Rights Week. We are at the Reginald F. Lewis Museum here to talk about what we're calling justice, justices, and just us, which is really talking about the sort of planned attack on civil rights and equity initiatives. I want to start by thanking our presenting sponsor, really all of Civil Rights Week, and that is the Reginald F. Lewis Museum, which is where we are right now. We've been very, very fortunate to be able to partner with the museum and to have their great support. I want to introduce the president of the museum. For those of you who were at this morning's breakfast, you heard her speak just beautifully about Martin Luther King Jr. and his letter from the Birmingham jail. And I declared her my sister, my newly found sister, because she said it was her one of her favorite writings from Dr. King, and it certainly is mine. And that writing formed a lot of our planning for Civil Rights Week. So it just really resonated with me, President Freeman, when you shared that. But here's a little bit about her. Terry Lee Freeman is the president of the Reginald F. Lewis Museum. She is a very strong leader, and that really is part of why the museum, when they brought her on board, declared her the president of the museum, not the director. She previously served as the president of the National Civil Rights Museum in Memphis. How many of you have been to that museum? It is really an extraordinary place. It was, if I have this right, it was formed from the Lorraine Motel. Yeah, it is in the Lorraine Motel where Dr. Martin Luther King Jr. was assassinated, and it houses so many artifacts. She was there as their president for 6 years. She previously served as president of the Greater Washington Community Foundation, and she was there for 18 years. She is a remarkable leader. We consider her as one of the women who are leading Baltimore, and if all goes well, you are invited to come back to the museum on Friday to participate in the celebration of the Women's Commission, and President Freeman will be one of the panelists as one of the women that will lead Baltimore. I give you President Freeman.
Well, good evening, everyone. I'm sure that this panel is going to be really interesting. I thought to myself, oh, justice, justices, and just us. That's a catchy title. You won't forget that. And I think it will prove to be very, very interesting. We are honored here at the museum to be able to host Civil Rights Week. You know, we don't think about these things. We don't think about civil rights until we don't have them. You know, we forget what it means to be able to walk into a store and purchase whatever we want to. We forget about the fact that there was a time when even up south, because that's what I call Maryland, Maryland is just up south, that there were places where we could not go. We forget about how difficult it was to cast a ballot. And we sometimes don't think about our brothers and sisters who literally were attacked for doing some of the very basic things that we just take for granted. And here's what I think is so important. They can be taken away. And we are seeing that now, which is what the panel is going to talk about. I know a lot of people, particularly younger people, do not understand why we say voting is so important when you don't get the result even out of the folks that you vote for that you would like. But we cannot change the system unless we're a part of the system. So I feel really strongly about how we must protect our civil rights, how we must be always on when it comes to these issues, and how, in fact, if there is one person who is not given their rights. That means all of us can at some point not be given our rights. So thank you for having this event here this evening. I look forward to hearing what you have to say. Thank you.
Thank you very much. So let's get started. I'll introduce our panelists, the first of whom is, try to do this in alphabetical order. Lana Asuncion Bates is also known as Dr. Lana. She has more than 20 years in the field of education. She's experienced in the areas of cultural proficiency and diversity. She's a graduate of Hampton University. I think we have somebody else in the office who attended.
Don't be shy, pirate. Don't be shy.
We like our pirates in the Office of Equity and Civil Rights. She majored in psychology. She received a master's degree from the College of William and Mary, and from the University of Virginia. She holds a double major in multicultural education and special education, and that's from the UVA. And she's been working in the diversity space for a number of years, and we are very fortunate that she has joined the Office of Equity and Civil Rights as our first ever equity trainer. Tanika Barber, to my far right, and I can just barely see the plants. She is the first ever Vice President for Institutional Equity and Chief Diversity Officer for UMBC. She's, as I said, the first to hold the positions that were created by UMBC President Valerie Shears Ashby. She serves on boards of directors, the Board of Directors of Community Law in Action, which I think 3 of us now serve. Judge Davis, as well as I, have served on that board as well. She has a bachelor's degree from Morgan State University, a master's of health sciences from JHU Bloomberg School of Public Health, law degree from the University of Baltimore. Previously, she served as the Director of Diversity and EEO Title IX Coordinator at Morgan State University. To my right is the Honorable Andre M. Davis, retired Fourth Circuit judge and former Baltimore City solicitor. He's kind of my forever boss. and Khadijah's as well. We both worked for him when he was head of the law department. For many years he served as a judge. Prior to serving as city solicitor, he was a judge on the Fourth Circuit Court of Appeals. And I mentioned that because it's one of the thought to be more conservative benches of circuit courts in the country, and it was often fell to Judge Davis to handle the diversity and equity decisions, and he always wrote so beautifully some of those decisions. And we had a little talk the other night about whether those decisions would stand in today's climate, and I hope that you'll share the answer to that with our audience. To my left is Joseph K. West Esquire. He's a partner at Duane Morris, which is a sort of large law firm. It's a large law firm here in the U.S. He is a partner and the Chief Diversity, Equity, and Inclusion Officer for the whole law firm. His work really is in the firm's trial practice group, where he handles complex litigation. And as I was writing this, it was taking me back to my own law career. And as I was writing, I'm like, yep, I'm not going to do that anymore. But really arising out of claims such as class action, insurance litigation, commercial litigation, zoning and land use, catastrophic injury, products liability, and labor and employment. Prior to Duane Morris, he was president and CEO of the Minority Corporate Counsel Association. And prior to that, and this is where I met Joe, he served as Associate General Counsel and head of Global Outside Counsel Management for Walmart Stores, Inc. And all of this background really informs where he is today. So that is our panel. Please join me in welcoming them. So what I thought we would do, and some of you might have to share the mic, but I thought we would start with just a brief background of affirmative action and affirmative action initiatives, which I always understood to be a move towards justice. And just a brief history of why those initiatives were started and kind of informs why they're under attack today. So I thought I was going to Judge Davis to give us that background.
Thank you, Dana, and I'm so pleased I'm so pleased to be a part of this distinguished panel. Affirmative action. It's not an exaggeration to suggest that the first official affirmative action taken by the United States government was actually the 1868 ratification of the 14th Amendment. The 14th Amendment to the United States Constitution, like the 13th, dealing with slavery, outlawing slavery, and the 15th, dealing with voting rights, were constitutional amendments adopted in the aftermath of the Civil War to do a number of different things. One of which, with regard to the 14th Amendment, was to mandate equality of treatment. The difficulty, of course, is that it's fine to mandate equality of treatment, but if you mandate equality of treatment for people who have not been treated equal and were not equally situated at the time, without importing into the meaning of equality a notion of equity, then you're losing the goal you're out to achieve. Unfortunately, the Supreme Court of the United States, in the years after the adoption of the 14th Amendment, gave it an interpretation that absolutely undermined the important goals that could have been achieved if a notion of equity had been included within the meaning of equality. Fast forward 100 years, and our modern notion and understanding of affirmative action actually arose during a Republican administration, believe it or not. Richard Nixon, in the late 60s, early 70s, before his infamous departure from the presidency, was the first president, actually, to acknowledge the wrongs that had been done in the business sphere and the need for the government and government contracting and employment to make amends to Black America. And so he issued an executive order in the early 70s that mandated the consideration of race when the military and the federal government undertook to hire companies and individuals to perform work and to provide services and products to the federal government. That was the birth, the pedigree of what we understand to be affirmative action. Over the years, of course, the idea spread widely into the private sphere. And what underlies affirmative action is a very simple idea. And the idea is remediation. A group of people identified by race was wronged, grievously wronged, for centuries. And the idea that underlies affirmative action is that government, state, local, and federal, and private institutions that have benefited from our history of slavery owe a debt to the descendants of those oppressed people. And so it became appropriate, supported by a wide range of politicians, thought leaders, social scientists, lawyers, doctors, hospitals, all across America. It became an accepted principle of the United States culture that the consideration of race in the distribution of benefits, whether it's employment opportunities, economic opportunities, educational opportunities, that it was appropriate for the government to make it possible for those who continue to suffer the consequences of our history of slavery and oppression to get better access, equitable access, if you will, to what our society had to offer. We'll talk a little bit more about the history and how it's been attacked. I'm sure Joe will pick it up from there. But that's basically the idea. remedying past wrongs.
Thank you, and you're right, I'm gonna pivot over to Joe to talk about some of the earlier challenges to affirmative action. Thank you for that background. And if you guys have questions, if you wanna just ask as they come up, we can go forward that way, rather than have to wait till the very end. Because really what's happening here, you're getting a master class on affirmative action and really justice. So, Joe.
Thank you, Dana, and thank you. I'm so honored to be here with this distinguished panel as well. As Dana indicated, I've known her since I was in-house at Walmart. She was one of my outside counsel, and as much as she says she didn't enjoy doing that kind of work, she was extraordinary at it. So I'm thrilled to be on this panel. I think the ancestors would dictate that if we are having this conversation, we have to talk about some of the sons and daughters of Baltimore. I'm tickled when I hear people talk about Philadelphia being the cradle of our democracy. We haven't been a democracy except since 1965, in my opinion. And so in this city, I cannot be here without thinking about Justice Marshall, a son of the city of Baltimore, and what he contributed to the entirety of our legal and societal ecosystem. I can't sit here and not think about the fact that the American Bar Association was established in 1878, and it took 143 years before the first black female president of the American Bar Association, Paulette Brown, who was born and raised and educated in the city of Baltimore. And in between those two bookends is my fraternity brother, Reginald F. Lewis, in whose structure we sit here today. Let me remind you that this is the 30th anniversary since the death of Reginald Lewis.
Mm-hmm.
He was 50 years old when he died.
Mm-hmm.
1993, 50 years old. He was the first black businessman to lead a billion-dollar company.
Mm-hmm.
And the reason I mention him is not just because this beautiful edifice is the fruit of his foundation, but because in the 206-year history of Harvard Law School, there's only one person who's been admitted to Harvard Law School without having to apply. That's because Reginald Lewis went to an affirmative action program through the Rockefeller Foundation and was so extraordinary that Harvard said, we need him. And look at what he did. And so we can't sit here in Baltimore in this building and not talk about Reginald Lewis and what affirmative action looks like, what affirmative action does, not just for the individuals who are the beneficiaries of it, but for the whole ecosystem. And so I wanted to start my remarks off by giving and paying respect and homage to this city, to the sons and daughters of this city, and what they have contributed to all of us. So briefly, I will say this, and we were talking about this in the green room. The opponents of affirmative action have been busy for a long time. You go all the way back to 1978 to the Bakke decision, right? When the first chips started showing, the Bakke was, a white male who wasn't admitted to the University UC Davis Medical School, and he said, well, I didn't get in because less qualified black folks were getting in, right? And even though affirmative action barely survived, what it said was, well, you can't have quotas, right? Fast forward to the Greta decision, which was, I don't remember how long ago it was, Your Honor, maybe 10, 12 years ago, right? And that transformed and sort of moved the discussion into the educational, higher education system, right? But the thing that's really important, Dana, is not so much what happened before the Harvard decision, but what's happened since then. And the ways in which the opponents of affirmative action, really are the opponents of equality, have taken that decision, which was really narrow in its scope, if you think about it. It just focused on the use of race in higher education decision making. They have taken it in a very strategic, very tactical, almost surgical way, and applied it to a number of different areas. The most insidious, in my opinion, is the Fearless Fund lawsuit, if you're not familiar with that. The same group that was behind the Harvard decision, the same group that was behind the Harvard lawsuit, They filed a lawsuit against a venture capital fund that had a very narrow focus, giving relatively small grants, about $20,000 each, to Black female-owned businesses in basically the beauty industry. Now, the venture capital universe is about a $200 billion universe, but they're suing a venture capital fund that gives small grants to Black female-owned businesses of around $20,000. That's designed to have a chilling effect on anything that's designed to help benefit Black people. And that, I think, is the most important part of this discussion, sort of like the psychological warfare that's taking place.
Yes. All applause is welcome. And it really is, the lawsuit that Joe was referring to is Students for Fair Housing, not fair housing, I'm sorry, Danielle, it's always on my mind. Danielle does our fair housing litigation. Students for Fair admissions cases, and they have so far sued Harvard, University of North Carolina, most recently a lawsuit, and you guys will correct me if I'm wrong, filed a lawsuit against the Naval Academy right here in Maryland, as well as West Point.
That's right.
So,
And then I should also point out the lawsuits against major law firms. They sued Perkins Coie and Morrison Foerster as well over their minority scholarship programs.
all by the Students for Fair admissions. So I was going to turn to Tanika and ask, if she could talk a little bit about what led to that litigation. And Tanika has a unique perspective because she is with UNBC. And when you were preparing for tonight, you shared something interesting that I would love for you to share with the audience about how UNBC sort of has girded itself against this kind of litigation.
Sure. I also have to just stop and thank you for allowing me the opportunity to participate in this esteemed panel. It's my pleasure to be with you this evening. In terms of how this litigation began, it actually began almost 10 years ago. So the lawsuit was initially filed in 2014, and there were two separate cases. One against Harvard, which is the oldest private institution in the country, and then the second against UNC Chapel Hill, which is the oldest public institution in the country. And so they were challenging those institutions' use of race as a factor in admissions. So like hundreds of institutions used to do, right? They considered race as a part of their admissions process. It was just one factor in different areas that they looked at each institution. So they considered academics, they considered test scores, they considered letters of recommendation, extracurricular activities, right? So race wasn't the only factor, it was one of many factors that these institutions looked at in their admissions process to diversify their student body. That was the overall goal, was to diversify their student body because they knew there was a legitimate interest in doing so. Diversity of thought within your campus body, training and building up a cadre of diverse practitioners that would go out in the field, and just having a diversity of thought within everything that you're doing throughout the institution. So their practices were not unlike any other institution, right? Many of the institutions at that time. However, in the Harvard case, there were some Asian American students who did not get admitted, and they hooked up with the Students for Fair admissions and filed that lawsuit against Harvard, and then that same entity filed the lawsuit against University of North Carolina, Chapel Hill. And it took, as I mentioned, 9 years for it to make its way through the courts. And every lower level federal court that heard those cases, so they were making their way through the courts separately, right? They weren't combined until we got to the Supreme Court. So all the different individual federal courts that heard the case, they upheld the use of race as a factor in admissions, saying that the universities did have a compelling interest and their use of race was narrowly tailored to meet that compelling interest. It wasn't until we got to the Supreme Court that they overturned decades of precedent that allowed institutions to be able to use race as a factor in admissions. And so to Joe's point, I'm sure we'll talk about this a lot more in the panel, although the decision was narrowly tailored to just focus on race, we are seeing it being weaponized to expand a lot broader, to cover different areas. in the higher ed space, in the employment space, in the venture capital space. And so to Dana's point about UMBC, we're in a very unique situation here at UMBC because we, in Maryland, there was a Fourth Circuit case in the mid-90s for the Kerwin case. And in that case, we had a Hispanic male filed a lawsuit against College Park because he didn't qualify for scholarships that were limited to just African Americans. And so the court overruled the use of race in scholarships, right, that didn't kind of adhere to that strict scrutiny standard, having that compelling interest and narrowly tailored. And so based upon that decision that came out in the Fourth Circuit in the mid-90s, UMBC really followed a suit in kind of overhauling all of our admissions practices in the mid-90s, thinking about more broadly our scholarships, our types of merit programs. If you think about UMBC, you probably heard about the Meyerhoff Scholars Program, right? So in the late 90s, because of that Kerwin decision, we opened up the Meyerhoff program to all individuals. So it started being limited to just African Americans. But because of that Kerwin decision here within the Fourth Circuit, UMBC really proactively took some measures to make sure that their programs were legally sound, right? And so as it relates to the impact of this Supreme Court decision on our use of race and admissions, we didn't use race and admissions since the mid-90s because of that Kerwin decision. So we're not immediately impacted like other institutions are in terms of having to pivot in terms of how they want to diversify their student body because they can no longer consider race as a factor in that admissions practices. But I'm happy to kind of talk about that a little bit more in terms of UMBC's practices.
Yeah, we do want to hear about that. I want to pivot over to Lana, and one of the reasons that I wanted Lana to be on the panel is because of her background in psychology, and I just simply remember being on I think somebody else, you might have been on that call too, but being on a call on an anti-racist in an anti-racism workshop, and we got the decision came down, I just remember feeling immediately, oh my gosh, you know, this is such an attack on Black and brown people, this SCOTUS decision, and it was just such a disheartening ruling. And so in talking with Lana, she wanted to share some ideas on how we can all sort of prepare ourselves to better respond to litigation like this from an psycho-emotional perspective. So I want to just pivot to Lana talking about that, and then we're going to come back and talk about the lawsuit, the litigation itself. So Lana?
Thank you again, Dana. I'm a follow suit, and thank you for having me on the panel. I just started with the office, so talk about jumping in with both feet. I'm already up here as a panelist, but I love this, and I was so excited that Dana had me here. I approach this work from a psychoeducational background. That is why I got into the work that I do, and I think about how these legal ramifications, the laws of policy, how they impact the humans, right? They're created to manage behavior. They're created to bring cohesiveness to society. They're created for humans. And what I think it gets so lost sometimes is the actual real life implications that these decisions have. Dan, you said, how do we prepare ourselves? We've been fighting this since the inception of American education, as we're going to talk about really affirmative action in the education system in particular. Knowing that American schools were never created to educate and to uplift anyone who looked like me and anyone who looked like maybe you, unless you were a white male, right? And so that was the beginning of our American education system. So when we talk about kind of building equality or trying to bring in equity into the system has been broken from the very beginning. And it's important for us to know that we have been surviving and thriving in a broken system, right? And so we've had to develop a number of different cognitive processes that have allowed us to persevere. And we, as a community, are stellar in that. The shadow side to that is in our grit, in our perseverance, in our strength, we don't always recognize the trauma that we are experiencing, not just firsthand but secondhand as well. From just hearing about the fact that we have to be, as a community, discussed and debated around whether or not we should be or are allowed to be in certain spaces after all this time. Giving the story of people who have been able to get into these systems without even having to apply. That's how high the level of excellence was. However, we are continuously trying to prove for standards that are not even solid or not fair at all, that we have the ability to not do just as well, but better than. And so we know from research, and this is statistics that have been out there for a very long time. Number one, when we have educational systems that allow for diversity in thought, those educational systems do better. When we do that for businesses, those businesses do better. Diversity is not just a color or a person, a number. It is a collective of perspectives that allows that institution to be stronger. So this affirmative action, as we're trying to kind of climb up this hill created to have us not even recognize the excellence that we're already bringing to the table, let alone try to help us feel like we don't have a seat at the table. It is something that we as a community have had to deal with for a very long time. When we think about affirmative action today, we're discussing it and the ramifications in the future. We have students right now in college who are already, especially for these universities that are really fighting back hard, those students, we already know from the data and research, they already don't feel welcome. Mm-hmm. They already don't see professors that are like them. They already are one of few in the classes. So they already have surmounted so many obstacles to get to where they are. And now there's this discussion around whether or not they should be there. So when we talk about how to handle this, how to deal with this, we have to recognize that this trauma that we have been living, that has been in our bodies, that has been passed on for generations, that is a real entity. And when we talk about how this will impact us in the future, affirmative action is about access. And without access, we have innumerable social outcomes. And when we talk about how this impacts our students and ourselves emotionally, mentally, it is really imperative that we recognize the history of trauma that we've experienced. We have to be ready as a community to really talk about it, because that is another thing within our community. With that perseverance and that grit, we sometimes, like I said, don't remember that we have real trauma that we have to heal, and we have to, as a community, really get comfortable with talking about it within ourselves and getting into a place where healing is something that we are receptive to. And we have to deal with this on a macro to a micro systemic approach. We have laws, we have people out here trying to fight and change policy and procedures, but we also have to understand, again, how this is going to impact the level of the graduates, numbers of graduates that will not come out of these institutions that are Black and brown, that are doing mental health counseling, the number of graduates that are not going to be able to be in these institutions to continue to push forward and have billion-dollar businesses, and to be lawyers and doctors and stand up and be those advocates for the other ones that are coming behind them that look like them. So cutting off this access, particularly in the education system, the way our country is set up, is a death blow. And it's been something that we have been overcoming for decades and decades and decades. I'll stop there for now.
Right, very strong, and of course, I think there was universal, well, at least on this panel, everyone agreed with you with that assessment about it being a death blow. And I thought about it as, if you really want to, crush, a culture, crush a people, take away their access to education. Mm-hmm. And we're seeing that happening legally through the court system. And, the Fourth Circuit, serving on the Fourth Circuit Court of Appeals is just one step away from being on the Supreme Court. And I mentioned in the introduction that Judge Davis issued a lot of opinions that were very pro in support of Black and brown folks and decisions of businesses. And I asked, as we were doing a prep session, whether he thought those decisions would stand with this particular court. And I think his answer was no, but I'll let him answer that. But I also want to hear, all from all of the panelists, just sort of some insight as to how we got here. How did this case just even begin to develop? But also, I think we have to talk about the makeup of the court. And the SCOTUS 10 years ago might have gotten a very different decision with the SCOTUS of today. So,
Yeah, I'll jump in and just very briefly, as Tanika said, these two cases in particular, the North Carolina, University of North Carolina case and the Harvard College case, in each instance, the lower federal courts upheld the behavior of the two universities as entirely consistent with existing law. Existing law. And it was the change in the law that the Supreme Court affected. This present court, with 3 appointees by the previous president, who, in keeping with the point of view that we've seen, as Joe said, for many decades, affirmative action has been under attack for many decades, virtually from the time Nixon first announced that color could be considered, race could be considered in government contracting. There were attacks on that program. And over the decades, courts, including the Supreme Court, rendered decisions that upheld the use of race as a factor in the consideration of the distribution of government and later private benefits. So they changed the law. What's so hurtful to some of us is that in changing the law, they did it in a way that didn't just say affirmative action can no longer be used. They actually reverted to the myth of a colorblind constitution. What do I mean by that?
tell us.
They issued an opinion which very powerfully says to America, race doesn't matter. Hear me. The opinion says race doesn't matter, and it may not matter in anything government does or private individuals do with the use of government funds in the distribution of public benefits. We all know race matters. Race matters in this country more than anything else. Yeah. We know that. And you know what? Those 6 Supreme Court justices know it as well. So you have to ask yourself, what is it that motivated this dramatic change in the law? And the answer is politics. Their view of the political economy, and the Chief Justice's opinion says, among other things, life in America is a zero-sum game. What he meant by that was, if you get something, then I'm not going to get it. And my team, his team, the Chief Justice's team, and I'll say it, the Republicans' team want it all. And they don't care, they do not care about the history of race in this country. And, I love to say, you all know this, the word slavery doesn't appear anywhere in the Constitution of the United States. Think about that for a second. They bent over backwards and did all kinds of, linguistic jujitsu, 3/4 of a person and all of that. And they wouldn't put the word in the Constitution. It wasn't until the 13th Amendment, after the Civil War, that the word slavery finally shows up in the Constitution. And here's one more piece of the legal background, and then I'll give somebody else a chance to bring it. it didn't have to be this way. It really didn't have to be this way. America didn't have to be the ugly country it has become. Early on, and even later on, as late as the 1980s, there were justices on the Supreme Court who quite legitimately had the view of the Equal Protection Clause, the 14th Amendment, that said this: the purpose of the 14th Amendment was to make sure that everybody gets treated equally. Amen. Right? But when it comes to former slaves and their descendants, we know they haven't been treated equally. And so we have to interpret the 14th Amendment to allow consideration of race at least until we achieve some minimum level of equality in this country, which everybody knows that's going to be hundreds of years, if we ever get there at all. If we ever get there at all. And for reasons that we don't have time to get into tonight, those justices, including Thurgood Marshall, right, were only 4. And you need 5 in the Supreme Court of the United States to make a rule of law. Mm-hmm. And what we've seen in this current group of 6 is that even when you make a rule of law with 5, later on, they can come along and reject it. And that's exactly what they've done. So it's a very dangerous time we're living in. Hate is growing in this country. There are those out there who are spewing hate, who are targeting people of color. And this affirmative action fight is of a piece of all of that. And those of us of goodwill, with the ability to do so, let's continue to fight back.
So, amen. I know you don't applaud.
So, first of all, this is a reminder to me of the fact that I've been a fan and an admirer of Judge Davis for many, many years. I'm privileged to have a chance to meet him in person now, mainly because his son, Ahmed, is a good friend of mine. He's one of the most brilliant lawyers that I know. And Judge, for years, he has talked about his father the same way I used to talk about my dad. So I'm just honored to be in your presence. The one thing that I will ask you to do is to read Justice Ketanji Brown Jackson's dissent. It is searingly brilliant and will bring you to tears because she does a phenomenal job of expanding on the point that the judge just made, which is that race has always mattered, still matters, and will always matter. She looks at hypothetical individuals whose ancestry has brought them to the point where one has an advantage in the University of North Carolina and the other does not. And she talks about those historical advantages and disadvantages based simply on nothing but the color of one's skin, and illustrates how you cannot just do away with that by legislative or judicial fiat, which is what the majority has tried to do. Please read Justice Jackson's dissent. It is brilliant.
Well, to make sure that we share that, at least within the Office of Equity and Civil Rights. So it is brilliant. So one of the reasons that I wanted to put this panel together is the concern that any government-based program, even like our office, y'all, that looks at race as a factor in what it does in any way is at risk. And I wanted just to hear from, I'm going to start with you, Tanika, and then go to Lana. Just your thoughts on whether my concern is real, because I know a lot of people share it.
Your concern is very real, right? And so I would just say it didn't necessarily start with this decision. right? We had the years of precedence as it relates to admissions, right, supporting the use of race in admissions. But people challenge DEI work always, right? As long as we are in a society built on concepts of white supremacy, they're always going to challenge DEI, right? So this is not a new concept for those of us that have been doing this work. And so we have seen already people use this Supreme Court decision, as we stated, to expand it to other areas, thinking about scholarships, right? Thinking about employment, as we mentioned, venture capital, right? And DEI programs in law firms. And so it is not in your heads, right? That this is going to be a fight that we're going to have in our hands for a long time. I think I'm a little more optimistic than Judge Davis, though, right?
Judge Davis.
I hope so.
Yeah, Judge Davis, when I asked him, he said, look, I'll be on your panel, but you better find somebody more positive. So I hope that's you.
That is me, right? Because I do this work, and so I have to see the light at the end of the tunnel to be able to do this work, right? And so it's not just a Supreme Court decision. We also have, for us in education, the Department of Education Office for Civil Rights. They enforce Title VI of the Civil Rights Act, which prohibits discrimination on the basis of race. They also enforce other civil rights-based laws that people have been using for years to chip away at civil rights and DEI-related initiatives on college campuses. So this is not a new fight, it's just a new front that we're fighting, right? Another weapon that we have to kind of ward off in this DEI-related work, but I am here to encourage you, right, to continue to move forward in that. There are different ways that we just have to maneuver in trying to diversify our student body. It really is going to start with thinking about what your mission statement is at your institution and infuse DEI into your mission statement, and then craft your programs or activities, craft your admissions criteria, craft your recruitment of your faculty and staff to meet that objective in your mission statement, right? So we just have to work a little bit harder, which was their goal, right? To force us to have to work to try to diversify our student bodies, diversify our workforces, and all this work that we're doing in the different rounds in the DEI-related space. But the fight still goes on. We still have tools in our toolbox to make sure that we can continue to advance these efforts, particularly in the higher ed space.
I'll jump in on that as well. This idea, like you said, is it serious? And it feels more serious to me, being in the field for over 20 years. Before, DEI work was kind of a pushback, but it did have the federal backing at the very least. So you had companies, you had educational systems that were required, and then you just had to kind of work over the barrier of, oh, we have to do another DEI session, another DEI workshop, but at least it was being backed by the federal government. Now, with that being, rolling back and not being there, diversity practitioners, with the ground that we had is very shaky. Even like we're saying, getting down to the nitty gritty of what do we call ourselves? Can we even use the word diversity anymore? I mean, that level of chokehold around the work that we're doing is extremely scary. Knowing how hard it is to reverse these decisions once they get to the Supreme Court, and knowing that this can be going on for decades if we can't do something revolutionary to change it is extremely scary. And so, again, when we talk about how do we support our folks, I want to go to the colleges in particular. What I have been hearing is that it doesn't matter what they call us, we're going to still do the work. It doesn't matter what the office is going to be labeled, we're going to still do the work. Race itself is a social construct that changes over time. The Supreme Court and laws have changed what the identity of white is, what we have determined to be African versus any other ethnicity or culture. That has changed a lot. And so we already know that we are creating this law on such a shaky construct with real outcomes. And when we talk about, how we're going to navigate, we have to be nimble and flexible, being very clear about what it is that we're here to do, and staying true with that, and having the people who are right next to us that are able to help alongside us building our allies, building our networks and our connections, and using people who don't necessarily are seen in the diversity world. So when I think about college in particular, our counseling departments in colleges are extremely important places that we need to work with right now for our students that are in college. Having our college counseling offices being informed in trauma-based and race-based counseling, and being able to really deliver those types of services that are tailored to the real situations that our Black and brown students are facing in college right now. A lot of our counselors, are still kind of trying to get more culturally competent. And with this reversal, we'll see less of, like I said, people coming out that have that cultural competency to work with their organizations and their communities, as well as other communities. So definitely making sure that we use the folks that we have around us, do the work regardless of what it's called, and staying true to the heart of what we're doing, knowing that we're in rough waters. We've been for a very long time. And I honestly think it's going to take some revolutionary acts.
Right.
It's going to take some revolutionary acts on our part. It's not going to come from the top.
Amen.
And so
Amen.
Joe is chomping at the bits.
If I can just jump in real quick, Joe, I'm sorry.
Joe, or
But I
always defer to the judge.
I realized I didn't actually answer Dana's last question, and I just want to take very briefly, Joe, I'm sorry.
Judge, take all your time you need.
don't tell him that.
The last, before I retired from the court, I was on the Fourth Circuit Court of Appeals, and that court, like all the appellate courts, federal appellate courts, sit in panels of three judges to hear the appeals from the trial courts. And I was very proud of the last major opinion that I wrote before I retired in 2017. And very briefly, it was a case brought by a Black business owner and his wife against the city of Greensboro, North Carolina. And very briefly, the city had actually reached out to them as a Black business to bid on certain contract opportunities. And I'm not going to try to give you all the facts, but they didn't get the opportunity. And they claimed, they brought a lawsuit against the city and said that the city had used discriminatory criteria in assessing their proposal to do whatever it was the city was looking to purchase. And they lost at the trial court level. The judge threw the case out. And part of the judge's reasoning at the trial court level in North Carolina, this is in like 2010 or 11 or 12, somewhere around there. He said, but the city itself reached out to them because they were Black in order to give them the opportunity. See, that's the kind of quicksand that before we didn't have very many tools to work with. But now we have, and I wrote this opinion, and I believe it was the first published opinion in the federal courts that employed the concept of implicit bias. Many of you have heard of this, and it's not non-controversial. There are some social scientists and others who claim there's no such thing as implicit bias, and the tools that have been developed at Harvard, among other places, to identify implicit bias really don't measure what they think they're measuring. I happen to disagree. I happen to believe absolutely that there is implicit bias. That given the history of race in this country, all of us are affected. All of us, including Black people, are affected by the kinds of trauma and whole body experiences that we've gone through generation after generation after generation after generation. We carry within us pieces of this preference for non-Black. We do. And so I wrote this opinion basically saying, you know what? And I was able to cite some respected social scientists, and even a former judge, a very highly respected judge, who hadn't decided a case on implicit bias, but who had written an article about it, okay? And so I used what I was able to learn, and here's the thing. Dana said my court was rather conservative. I got 2 other judges to agree with me. I got 2 other judges. Now, in all honesty, I don't know if they read it. I don't know if they read it. I'm pretty sure they read it. Did they really fully grasp where I was going with this? I don't know. I don't care. But the bottom line today is that opinion, whatever I was trying to achieve by laying the foundation for a growth in the identification of potential racist bias, racial bias in our society. This Supreme Court case, the Harvard case, that, in my opinion, is going nowhere. There really won't be anything known as implicit bias in the courts once the final consequences of this Supreme Court opinion has full effect over the coming years. Thank you, Joe. I'm sorry.
No, Judge, I'm glad you made those points because 2 things you said that I think really resonated with me. First, the fact that all of us are impacted. All of us are impacted by bias and implicit and explicit bias. And your opinion you just talked about really posits this in a place that is so critically important, which is the business world. I will, as you were talking, I thought about a study that was released in September of 2020 by Citigroup. It's called The Cost of Racism. If you get a chance, just Google Citi, C-I-T-I, The Cost of Racism. And what the study showed is that in the first 20 years of this century, from 2000 to 2020, the US lost 16 trillion with a T in GDP because of systemic bias against African Americans in just 4 areas of commerce: wage and income disparities, lack of access to housing, lack of access to educational opportunities, lack of access to equal entrepreneurial capital. 16 trillion in GDP. The year the study was released, the entire GDP for the US was 19 trillion. In 20 years, we lost almost a whole year's worth of gross domestic product because of discrimination and bias against African Americans in just those 4 areas. Now let's think about that. It's just those 4 areas. We know that there are systemic biases in a whole range of areas beyond. I mean, we talked about education, we talked about housing. Dana inadvertently mentioned housing, right? And that's just discrimination against African Americans. Doesn't talk about other brown people and other people, LGBTQ people with disabilities. And the thing that's important to remember is this: every organism on the planet is motivated by self-interest. When you get people to understand how discriminating against Black people hurts you too, that's when you get their attention. And that's what's so critically important about this issue. You don't just harm us, you harm you. If Reginald Lewis had not been admitted to Harvard through that affirmative action program, look at the company he built and how many people he employed and how many individuals he assisted and how many peripheral businesses benefited from that. It's gotta be a way in which we get people to understand that it affects them too. I'm gonna give you one small example of something that we did at our firm that illustrates this point. When I got to our firm, I realized that we had, Dana mentioned I'm a partner at a global firm. We have about 920 lawyers and about 30 offices around the world. One of the things that I did was I took a look at the reasons why a lot of our minority associates left the firm. What was the reason around the attrition? The good news is that we weren't one of those large firms that people just ran out of there with their hair on fire saying, I hate this place. That was the good news. The bad news is that a lot of them, through exit interviews, reported that they weren't getting an opportunity. You know, we were recruiting these extraordinarily talented and gifted minority attorneys, but the partners who were handing out work were giving it to certain people and not other people. There was a lot of affinity bias at work.
Yes.
If you looked like the partner who had some work, same gender, same race, went to the same school they went to, you played lacrosse, okay? You were getting work. But if you looked like me, or you weren't getting it. So that talent we were bringing in was being left to wither and die on the vine. So I put together a blind rotating assignment system where every partner who had work had to give out work on a rotating equal opportunity, a democratization of opportunity.
That is revolutionary.
And we incentivize those partners in the old-fashioned way, money. Because guess what? When you tie money to result, it clarifies the mind. You know, it gives people attention. You got full focus, right?
That's true.
A portion of your annual bonus and your review and your increase was tied to the extent to which all of the associates in your group got an opportunity for work. And guess what happened? We cut our attrition in half. When I joined the firm in January of 2016, our minority population was 11%. We're at 22.3% now. And guess what else happened? A lot of white males who weren't getting opportunities got opportunities. It cut our overall attrition in half. So guess what? We benefited, but so did you.
This is what I like to call raising the table, right? Raising the water level. And there's a really wonderful analogy that Dr. Angela Glover Blackwell put out, the curb cut effect. And so what you're talking about, and I think the frustrating piece is that we know that we have laws that are working against the best interests of all and working against the best interests of those that are actually supporting these laws in particular. But we also know that the United States has had the opportunity to understand how we can actually benefit and help those who they deem worthy. In the 50s, during the American Disabilities, it was an American Disability Act, there was a whole reform done because in the 50s there were a small population of people, I think at that time maybe it was 8 or 9% at the most, who were considered physically disabled. And the federal government said, well these folks first they caused a ruckus, right? They said we can't get into public buildings, we can't get to the post office, we can't get to our grocery store. We're physically disabled, and these stores and these places have not allowed access to us. Again, a very small amount of the population. And the federal government said, hey, this is not right. This is a civil rights issue. And so what they did is they required every place that should be accessed publicly to be able to be accessed by people who are physically differently able. And they put in, one of the things they put in were curb cuts, right? So at that time, those were created for a very small percentage of the United States. Some would say negligible as far as the numbers are concerned. Of course, there are people there that are experiencing these everyday realities. So what the government did is they put a good amount of money at the time in making sure that all publicly accessed buildings had the ability to be publicly accessed, putting in that curb cut. What we know now is that everyone uses a curb cut. People are upset if they are pushing their stroller, if they are riding their bike, if they are on a scooter and they cannot get into a store, they can't get up the steps. People who are physically able are very upset about the fact that they can't access something because that was granted as a civil right that was supposed to be for a small group that ended up benefiting all. And so when you put, instead of this, the affirmative action, we have it upside down. We're trying to get a piece of this pie or trying to get to the top of this hill when actually, if the powers that be really wanted to make a difference, all they would have to do is take that money and focus it on the most marginalized, the most vulnerable communities, the people who have that intersectionality of race, of gender, of ability, of LGBTQ, of gender identity. Put that in, and those become smaller numbers. Put that money and resource there. And what you will find, what you just noted in with your firm, is that by proxy, everyone benefits.
Yes.
It's called raising the water, raising the table. By lifting up one ship, all ships rise. We have the ability to do that. We've seen the country do that, and yet we've also seen how the country time and time again decides to not do the things that we know they can do for the people that they have deemed to not be worthy.
Right, so we often talk about the phrase, a rising tide lifts all boats. And from an equity perspective, I've always thought, but what boats are we talking about? Because we're not all in, literally not all in the same boat. We have different boats. But, I mean, your firm's example, it was an experiment that worked.
Yeah.
That absolutely worked. And you know, when you bring money in it, that can be the great equalizer, because it is it's a huge motivator. But we have seen so many decisions and so many outcomes where people were absolutely not acting in their best interests. Now, we see that people are willing to vote and to support for someone who actually hates them, who actually hates what they represent. How is that, who does that work? Who, if he comes back, is gonna destroy them and what they represent and what they think they stand for. And yet, like, y'all been talking, let me talk about that.
I'm amening it.
Oh,
That's how we come from there. My dad was a minister. I'm amening.
But there it is, all right, Tamika.
I actually wanted to piggyback on Joe's example about opportunity, right? And kind of bring it back to the higher ed space and us, or institutions, particularly those selective institutions like a Harvard and UNC, having to work harder to get us in the door, right? And because that, in my opinion, was the main focus of these institutions, just getting us in the door. Now you have us in the door, now what?
Yeah.
What are the opportunities? Am I included? Am I graduating, right? Do I see faculty and staff that look like me? My hope is that this decision will cause all of our institutions to focus more on that inclusion and belonging piece that still is a part of DEI, right? It's not just one letter that's in there. Belonging, right? Now that I'm here, what are you going to do with me? What kind of supports and systems do you have in place to support me as I'm matriculating through your institution and helping me to be successful, creating opportunities for other people, creating those curb cuts, right? Like you said. And so that really stems back to why I have such a hope for this in the higher ed space, because I think we can use it to transform overall how we deal with Black and brown students in our institutions, beyond just having adequate numbers of them within our institutions, but how are we caring for them? How are we supporting them, nurturing them as they're matriculating through our institutions?
And that is really what I'm really concerned about is the decisions just seem so dire and so dark and so weighty and so negative and so, you know, gut-wrenchingly bad. And when I talked to Judge Davis, and he did say to me, well, you better find somebody more positive than me. And I thought it would be Joe, but it is not Joe. Okay.
It's all about the
Well, let me say, he has given us no hope. There is no hope for service. So what I want to do is just go down the panel. I'm going to start, I'll go back to you, Joe, then I'll go to Lana, then Andre, and then Tanika. Just what do you think, where is the hope? What is it that we should be thinking about and doing as Black and brown folks?
Well, the hope is in this room. The hope is on this panel. The fact that we have people who care about this, who are willing to talk about these issues, who are willing to do the work that each of you are doing, including everyone in this room, gives me hope. I will say to you that, you know, I said this in a meeting at our firm. I'm on our global management committee, and we talked about this, and I said, this is gonna sound counterintuitive, but I think this is a good thing in the long run for us, because it's kind of the way in which banks have to undergo stress tests to make sure that they can withstand attacks. If there are changes that we need to make to what we're doing, so be it. But overall, people are going to need diverse populations in this country. There is a certain demographic inevitability that's been at work for 30 years now. The most recent census report for the first time showed that the majority white population, which had been slowing for decades, actually decreased for the first time. And so the clients that we deal with in corporations, they are steadfast in their desire to continue focusing on diversity, equity, and inclusion. I'll give you just a quick story about when I was at Walmart. I joined Walmart in the end of 2006. Walmart was opening 300 new stores a year in the US alone, right? The legal department was not very diverse, but the GC who recruited me to the department, Tom Morris, was charged with the responsibility not of making the department more diverse, but making it better. Because the department was still small, the company had grown to be a global Fortune 1, and the department was still being run by I'm gonna be charitable here, but kind of the same group of Arkansans who had been servicing the company when it was a small regional concern tucked away in the Ozark Mountains. And they needed bodies and horsepower. They just needed to be bigger. They needed people with broader skill sets and experiences. And Tom, by pure happenstance, was invited to be a guest speaker at a conference, the Minority Corporate Council Association. And he had, his words, not mine, an epiphany. He said he never realized that there were that many extraordinarily gifted and talented, diverse lawyers, right? To his credit, he came back to Bentonville and he said, I want us to put together a list of all the major affinity bars in the country, and we are going to support them with money. We're going to recruit from there. I was recruited through that initiative. In about 18 months, the department tripled in size. It went from like 15% minority to 27%. It went from 20% female to 43%. And an interesting thing happened. The quality of the work went through the roof. The evaluation that Walmart's internal business clients gave of the legal department soared, right? As the department became more diverse, the quality of the work got better. And then the same thing happened. Dana mentioned that I was in charge of the outside counsel management function. We did the same thing with our outside law firms. We fired all of the relationship partners and had all of them to reapply, but they had to include at least one woman, one person of color. In about 2 years, we shifted $60 million worth of business to women and minority relationship partners, women and minority owned firms. And again, the quality of the work went through the roof. I mean, it was amazing how much better the work was. And I remember my general counsel asked me, well, what do you think that is? I'm like, okay, I'll do an analysis if you want me to, but I don't. You know? But it was a couple of things. First of all, we are socialized to understand that if you get an opportunity like that, you got one shot, right? You're gonna get the quick hook, and you're not gonna get that second chance like other folks are gonna get second, third, fourth, even fifth chances. So when somebody who looks like me was at a firm, Dana's a perfect example of that. She was killing it at the firm she was at when I hired her. We're like, oh, I got a chance to work for Walmart, I'm gonna knock this out the park. I'm gonna be super responsive, especially if the person I'm reporting to internally is somebody who looks like me, because I have to have his back, right? The other thing is that a lot of lawyers in those firms were underutilized and underappreciated in their respective firms. And so they knew that this was their opportunity to do excellent work. The last point is, if you're a partner at a major firm and you're a black, brown, or a black, brown female, you have gone through things to get to that level that your colleagues cannot imagine. So you are an extraordinary somebody, right? And that's what I thought. Yes, exactly.
Yeah.
And so I tell that story to make the point, and here's your ray of sunshine and hope. The concepts of diversity, equity, and inclusion, and the concepts of excellence are not mutually exclusive. They are interdependent. And these are the kinds of messages that we need to get people to see, appreciate, and understand.
Wow, we could end on that note. I feel better. I think we're gonna go to Lana. Did I say Lana?
I think so.
Okay. Is that okay? All right, Lana, Andre, Tamika, the last word.
And so I guess our parting words, is that what we are doing?
What gives you hope?
Just what gives me hope.
Where is the hope?
I know Dana asked me to be the positive one as well on the panel, and I couldn't promise her positivity. Revolutionary energy is what I can give. One of my favorite quotes is Audre Lorde's, for the master's schools will never dismantle the master's house. I believe that even more now that I've been doing this work for as long as I've been doing it, not believing that we would be here today, in this country today, dealing with the things that we're dealing with. And so I do believe that it's going to take some very courageous acts of revolution, which we have been doing. That's what Civil Rights Week is all about, is revolution. We have to be revolutionary in the way that we approach this. Until we can change the system completely, and we can't do that using the master's tools within the master's house. We have to take the things that we have already built, the things that we've already collaborated with, things that we've created, and use those places as we try to navigate that. So I'm thinking particularly with higher education, I'm thinking about our HBCUs, and I'm thinking about our community colleges. It does not surprise me that the first two institutions are the institutions named in this suit, UNC and Harvard, the first public school and the first private school in America. That does not surprise me that those were the two schools that are named in this suit. I think it's very clear that it is a message being sent, again, that this is not a place for you unless you can somehow get into the good spots. You know, the place where you can assimilate, and that's not why we're here, and that's not what we're doing.
Don't
and
forget,
so,
the decision carved out the military. So the next two places they sued were Naval Academy and West
it is
Point.
all very strategic. It is a chessboard that is very strategic, and so the places that we do have, we know community colleges in particular, they serve almost 80% of our Black and Latinx students in particular as a gateway to colleges. So first of all, making sure that our community colleges are strong and that they are supporting and being able to support the communities that are being most impacted. HBCUs are very vulnerable right now. We have to support our HBCUs, making sure that our kids have a place to go to be educated in a space where they can be. And again, I don't know how that's going to look with this in 5 years, or how HBCUs will be impacted by this affirmative action piece. But some of those privately funded schools that we have, we have that for a little while. So using some of the places and changing the narrative about what a good school is. Because we have Harvard, we have UNC, but we already know that they're going back on the data that they put out showing that implicit bias is actually something that is important. And now being named in this suit to say that we're going to be race neutral. It makes absolutely no sense. So why are these schools being applauded as these, important, huge schools? It's because that's the narrative that we have been living under for so long. Change that narrative. It may not be the place for you at UNC or at Harvard, and not to, alumni that have made it, especially Black and brown alumni that have made it and deserve that degree that they got. But we have this mentality that we have to, again, be part of something that was never created for us. So where do we find our spaces of safety and solidarity? Where do we use our gifts and put our money and resources into those places that are directly benefiting us, and change the narrative around what we think is good?
For all the old man grumpiness you hear from me, the fact is I am very optimistic, and I am positive for the very reasons that Joe and I just said so beautifully, and I can't improve on those. Two quick things though. First of all, I see this opinion and the consequences of this opinion to be, in many ways, the best news HBCUs have gotten in a long time. I believe that the consequences are going to be, one, resources, and I was so pleased to see, our great president of Morgan receive that award from Civil Rights Office today. The HBCUs are going to stand up and be what we know they can be. And here's the thing, imagine a Black student who gets into Harvard or MIT or wherever, one of these elite colleges. And for one reason or another, they figure out, if I go there, I'm going to be one of 3 or 4. I don't want to be in that community. So that student may well choose to go to Morgan or Hampton or Morehouse or Spelman or A&M, because here's what we know. For generations, Lana alluded to this actually. If you look at where black dentists, where black lawyers, where black doctors went to undergrad, they went to HBCUs. They went to HBCUs. So we know that those schools are producing, as Joe put it so beautifully, excellence. That's what they're producing. And number two, as Joe said, and as Lana said, we got this. We got this, right? I'm a black judge, and I'm so pleased to report, first of all, that here in Maryland, we have a new chief federal district judge named George Russell.
Right.
George Russell, black judge,
Yeah.
my student, my mentee at the University of Maryland School of Law. Another black judge here in Maryland, federal district judge. The first graduate of the Morgan State University, undergraduate, to become a federal judge in Maryland. First one. How did he get there? He clerked for me. He clerked for another black judge in Virginia. You hear me? We got this. Joe West got this. Dana Moore got this. We're not gonna let this turn us back. We've been struggling all these centuries. We're gonna show them. And we're gonna show them. And I agree with Joe, the people in this room got this. We got this. So I am
I have to echo everything that's already said, right? So this black lawyer is an HBCU graduate, proud Morgan State University, every day, all day. So our HBCUs are producing excellence, right? They are the places that already support us, already nurture us, but they are under-resourced. And so we have to infuse the resources in, right? We are going to see people turn to HBCUs, much like we saw after the murder of George Floyd, where people came to HBCUs. They're not second-tier institutions, right? They are stellar, premier institutions that are created for us, and we need to embrace that, right? And so that is my hope as well. Right, the hope also in terms of revolution is to double down. I am doubling down on my work, right? I am not retreating on anything. I changed the office name at UMBC to Office of Equity and Civil Rights, because that is the focus of what we're going to do, right? And we're going to lead by example. We have a president, African-American woman that is committed to this work. I was one of her first cabinet hires. So I am hopeful that we're going to continue to make a change and impact other institutions in this state, in this nation. Thankfully, we're in a state that hasn't overruled DI, right? Where we have 35 other states that have passed or introduced legislation to do so. Thankfully, we're in a state where we have some kind of shelter right now, right? And we're able to flourish and continue to advance this work and help other colleagues. So get with other people that are doing this work, strategize about what you need to do to make it happen. And as Judge Davis said, we got this, right? That is why I'm always hopeful, because we always persevere, we always persist, and this is going to be nothing different.
We have time for some audience questions, if there are any. Don't be shy. You've got the folks here that have the answers. Mr. Payton.
I know that this is probably, you all didn't mention this, but when they're talking about how the Supreme Court judges are being influenced by these billionaires to do certain things and how they don't recuse themselves, how much of that is influential in their decisions?
It's very influential, and I'm glad you brought that up, because I'm actually on a panel next week, nationwide panel, to talk about the ethics of those folks.
Or lack thereof.
And lack thereof. It is a real concern. It is a genuine concern, and we've got to keep the focus on that, because the behavior that they've engaged in is just unacceptable. It's outrageous. It's outrageous.
It wouldn't be tolerated in the city of Baltimore. Y'all know you gotta file your ethics forms every year.
Yeah.
We wouldn't get away with it, and it really is disturbing that. Yeah, I guess we'll stop there because it's being broadcast.
I mean, it wouldn't be tolerated in any other court but the Supreme Court.
Exactly.
Everybody else has a code of conduct, a code of ethics, but the Supreme Court.
It wouldn't be tolerated in most places of business, period.
Right.
Right. In my firm, it wouldn't be tolerated, I mean,
Not
that's,
for a
It's
second.
unspeakable.
Not for a second, not for a second. I see Charles and then gentleman in the brown flag. Your second, Charles.
Started to answer this already for me, but I have to ask. I sit on a private high school board in Baltimore, and I'm leading the DEI efforts for them. And we're talking about increasing the number of Hispanic students, increasing the number of Black students, and I have gotten really scared to even say, yes, I think diversity, equity, inclusion work in our board sometimes, and so I'm here in terms like race-based versus, instead of using race-based, use more so race-conscious. Only you're talking about things like admissions, improvement. But it sounds like you said Maryland is being shielded a little bit more in some of the other spaces. Did I hear you correctly?
So generally, in terms of the attack on DEI, Maryland hasn't seen the legislation in states like Texas, Missouri, Florida, that's totally dismantling DEI offices and taking away funding, right? We're not facing that kind of pushback here in the state of Maryland. But as it still relates to admissions, the Supreme Court decision is talking about the use of race. So you have to have race, we can't use race-conscious admissions, right? So think about race-neutral strategies, but there are other ways to, I don't want to say workaround, it's not a workaround, right? You still have a legitimate, authentic interest in diversifying your student body, but think about what your recruitment sources are, right? Can you think about some Title III schools, right? And go recruit from some Title III schools and use your staff, right, to kind of put out their feelers, right? Think about upward bound programs, right? Those different things that target individuals based upon other protected classes, right? And non-protected classes like socioeconomic status, geography, right? Location where people live. That's the way that you can kind of diversify using kind of race-neutral practices.
If I could jump in with that, exactly what you're saying, race can be used as a proxy for other identifiers that have almost as significant an impact. So again, geographically, zip codes, we know that can be very racially based. Areas in the community, whether northeast, southwest, or whatever, community. Thinking about even bringing in religious places and places of worship as areas of people who congregate around cultural identity, right? So looking at those areas that race has played a proxy of an identifier, another social identifier, and pulling up those identifiers as a way to kind of get around this idea of using race is one way, but we know that race is central to everything. We can't get away from it. Race is going to be the piece, but there's ways that we can work around it using those proxy identifiers.
Okay, great, thank you. Gentleman, brown flag. Yes, you.
So it appears to me that Clarence, opinions of Judge Thomas allows cover for some justices who may have some clear racial issue, because he's saying it,
So they don't have to.
so they don't have to, and how can I be?
Yes, the black man on the bench said it first, so
Right,
how can it be wrong about it?
so is that a hopeless case, or do you see
Yes,
any?
you are asking, is it a hopeless case that Justice Brown, what is his name?
Tom.
Thomas. That is hopeless,
And they don't care.
and they don't care.
They don't care.
But you know what?
If Thomas wasn't there, the outcome would be the same.
Right, and we don't have time for it tonight. We have talked about increasing the size of the court to 11 or 13. Can't talk about it tonight, don't even respond to that. But we'll come back, we've got a long year ahead. Kayla.
So you talked about, Your Honor, you talked about colorblind constitution, fallacy therein. And of course, you also started with constitutional conversation about how race has a stricter scrutiny now. So I guess my question is, if I write a bill and I want to pass a law that could pass the constitutional muster, does that exist in the race-based context? And if not, like what alternatives do I have? Other than, I mean, of course, we talked about some of the other indicia, but there are some things that need to be drawn out or expressly stated.
For those of you who didn't hear, Delegate Young is asking me for some free legal advice. how he can draft his bills. And I don't blame him for asking. I'd be asking too.
Send them a bill, Judge.
Yeah, it's going to be difficult. It's going to be very difficult. Now, as someone suggested earlier, it is, place matters. Place matters. So Maryland, we're fortunate to live in a jurisdiction where people of goodwill understand the value of diversity.
Yes.
That's not to say that some of those from outside of Maryland won't come in and challenge some of what you try to achieve, Delegate Young. But you got to be careful. You got to be very careful. And I can't say more than that. You got to be very, very careful.
We've got time for one more question, so John, you will be the last.
Okay, yeah, Judge, and could all of you, in light of what you're saying and the fact that President Trump is the leading Republican candidate, and guess who appointed a lot of the judges they've been talking about, what does it mean if this guy gets elected again, based on what you're saying?
Democracy is at risk. I'll limit my answer to that.
I will not be as optimistic, right? So my ray of hope will dimmer, right? Because they're playing the long game.
That's right.
Right? So that was his objective, was to appoint these justices to the Supreme Court so that they can dismantle civil rights.
Exactly.
We are not playing the long game.
See?
So we have to think more strategic about these things, and we have to get out and vote.
And that's just sounding like a conspiracy theorist. I've been getting into that hole a lot lately. It just feels crazy. But the thing is, there's this thing called the browning of America. There's a social concept that says that race, being a social construct as it is because of all of the ethnic couplings that we're having children that are not necessarily white and not, and they are other. And so what I think is really important to understand is that at a certain point, especially if we continue to go the way we're going, there is not going to be a definitive white majority in America. What this is doing is again, limiting access. So then when it becomes a situation where race is not even the proxy anymore, it is the classes, the have and the have-nots. And so again, when we talk about these things, it's beyond race at a certain point, because race is going to go away eventually, just like it came out of nowhere, it's going to go away. But it is what's going to stay is those who have power, who have access, the have and the have-nots. And that's where I think when we talk about long game as well, thinking even beyond this idea of race and talking about access to things that put us in different social categories around socioeconomic status, around educational attainment, around the network and the nepotism that we see, the connections and people who you know, all of those things are going to become, I think, more important. Those are going to be the higher prize than even race, because race is starting to become something that is going to be negligent as far as white and black and other.
But this decision chipped away at that access, right? So it was getting to that point, right? I can no longer get into those institutions to be that doctor, to be that lawyer, to be that teacher. So I won't have the access. I'll be a part of those have-nots.
Exactly. And race is being used as that grab all. Right. But as race starts to become a non-factor, we will have put in place those structures of access and limiting access to then continue to disenfranchise those who already started off at the bottom.
Okay. It is about 8:30.
Thank you, man, for all your work. and everything you do and what you mean.
Joe and his wife came all the way up from Montgomery County to be here to, I think, Montgomery County?
No, we live in Virginia.
Oh, it's even further south. Even further. Thank you so much for coming up and joining us. It's been a long day. Thank our panelists. You're terrific. Conversation to continue. Register and vote.
Thank you all for coming.